I'll find it for you later. These are working today. Wow, I have all this. How do I do it?
Okay. Conservation recommendations. So now we're kind of working our way down towards the bottom of a biological opinion. And this is sort of that place where Fish and Wildlife and NOAA can step back a little bit from looking specifically at the effects of the action on those species and think in a broader context and get a little more creative. This might be where we ask you to, well, we might make recommendations that would pertain to your 7A1 responsibilities. Does anybody remember what that is?
Sure.
Yeah, it's just using your agency's authorities to do good things for species conservation. So the objective of this exercise, we're going to just talk about, what are conservation recommendations and compare it a little bit with your reasonable and prudent alternatives and reasonable and prudent measures. So conservation recommendations, these are suggestions regarding discretionary measures to minimize or avoid adverse effects of a proposed action on listed species or critical habitat or regarding the development of information. So the key word here is discretionary. We're making recommendations and you can or cannot implement them as you see fit. We might identify measures that you could do to further avoid and minimize adverse effects resulting from that action. We might have felt through the BO that you got to the point where it was no longer a potential jeopardy or adverse mod, and maybe there's certain things that we think you could do in addition to your existing conservation measures and RPMs. We might identify specific studies that you could do. We're biologists. We always want more data. I'd ask you to develop new information, also with the data thing, such as maybe developing that motion detector. Or we might just make general suggestions on what you can do to assist further in species conservation. So all your conservation recommendations, it should clearly benefit the species. It can be more than a minor change. It might be something big like, we really don't like that alternative that you picked. Maybe you could try that other one. And it could be something just beyond the scope of the particular action that we're reviewing. And this is where it might pertain more to something from the recovery plan, like, we really need to be propagating this species. And conservation recommendations are not enough to remove mod determination because they're discretionary. It's not a commitment, so it's never enough to remove that determination. We're not obligated to provide them. It's probably a little hit or miss on whether we make conservation recommendations. I do quite often. I think Lourdes does a lot, and John occasionally. You're not obligated to implement them. And like we said before, it might be just advising you on some ways to implement your 7A1 responsibilities. We might advise you to set up a species conservation bank or enter into programmatic consultations. And Jerry's going to talk a little more about programmatics later, but usually programmatics might require a little more on your part to do good conservation for a species, sort of in exchange for having a faster review process. And so these can or might involve tasks in our recovery plans. And just a couple quick examples from District 3. We had a project recently for State Route 20 Chipola River Bridge replacement. This impacted 2 mussel species. And one of our general recommendations was that, we're starting to see a lot of these bridge projects. Maybe it'd be a good idea to do a programmatic consultation. And really that recommendation, that was our recommendation. I think D3 was thinking the same thing. Federal Highways was thinking the same thing, and so the central office. So really we're all on the same page that this might be a good step in moving forward. So work is now underway on doing a 2-part programmatic agreement for consulting on mussels. First looking at the low impact activities that DOT does in mussel habitat, and hopefully eventually getting to the point of doing a formal consultation. And also the US 90 Yellow River Bridge replacement. This is Gulf sturgeon critical habitat. An issue that's come up in the past few years is the effects of pile driving and acoustics on Gulf sturgeon. A lot of our decisions are based on best available science, which most of that comes from the West Coast in terms of understanding the noise levels that's coming from the pile driving activities. So our recommendation was to start monitoring and tracking the sound levels. So we've got data for Florida. And with the US 331 bridge, I think that was our first bridge where we started really collecting some sound data. So that's something that's going to be able to help our consultations in the future. A short session. Any questions? Yes.
So are these conservation recommendations, are these in addition to like terms and conditions of the DO, or?
Yeah, it's a separate section, but like I said, these are discretionary. The terms and conditions and reasonable and prudent measures, that's mandatory. You have to do that. And any conservation measures that are part of your action, you have to do that. That's like a commitment that you made. So these are just sort of that big picture thinking of, it would be nice to go this one step further. Yeah.
If you do implement conservation recommendations and they're having a positive effect on the species, is there a way to document that so it can be taken into account, the next time you come in for a consultation?
Like in terms of getting credit for it, or?
I don't know necessarily about credit scoring, but the environmental baseline for the next time should probably take into account. For instance, if you reestablished a connection between subpopulations in an area, or if you've done something to benefit the species,
right.
I'm just curious on the documentation for that.
I would think that would always show up positively just in the baseline for that species. I don't know.
Yeah, and the data, one of the last things we say in conservation recommendations is, please tell us if you do any of this stuff. And the reason is so that we can update the status of the species accordingly, because we don't have motion detectors out there, gauging continuously in real time the status of the species. We update that based on what information we receive. So if you're doing good stuff for species, tell us about it.
Is there any history of getting credits or something like that?
Oh, absolutely. Yeah. And in fact, our regulations, which you have in the back of your notebook, say that the service shall give consideration to beneficial actions taken by the agency in advance of a consultation.
Any other questions?
I guess you're up, Sean.
All right.
All right, testing. Yeah, that seems to work. Good. All right, so ahead of schedule. That's good. Means I can ramble more, right? Okay, so like Jerry said, I did revise my slides a little bit since you guys didn't like me writing on flip charts. So I changed my teaching strategy here. I've adapted a little bit so you can actually read what I've put on the slides. So the slides won't match exactly what's in your notebook. You have the major bullets there, but I've added a bunch of kind of other things that I was going to write on the flip charts there for you. So just a warning, you'll have all the major stuff that's there, but you probably want to take some notes as well. So we're going to hit two topics here, and both of these things happen after you get the biological opinion. So we're going to talk about reinitiation, which we already talked a little bit about yesterday. I think a couple of you asked questions about reinitiation, so Jerry went through some of that already. And then things that you have to do as the action agency and the services after you have the biological opinion. So we'll talk about those two things in a little bit more detail than we've talked about with the questions thus far. So we're going to jump into the reinitiation section first. We'll take questions, and then we'll go to the section of the module. So what do we want you to do here? Understand basically when reinitiation is required. There are 4 criteria. And you have to have the actual authority to be able to do so. So we'll dive into the details about that here. And then also that kind of control over the action. That's that you have to have that control. There are some circumstances where that doesn't exist anymore. So we're sort of out of luck in terms of reinitiating. So let's go into a little bit more detail on that. So reinitiation appropriate if you have that control in place. So what does that discretionary control really mean? We want to venture a guess, like what are some circumstances in which people would not have that control?
Not fairly funded? It's not fairly funded?
You wouldn't have a nexus in that to start with, so you probably wouldn't end up in the Section 7 process anyway. Think about permits. Yeah. In some circumstances, you may have a permit that's expired and you've got no means to go back and reactivate that permit. So in some cases, that'll be an example. We'll come back to this again at the end. So that's kind of the overarching, you've got to have that control still available to be able to reinitiate. And then there are 4 other criteria. And so any one of these 4 criteria has to be met. So you've got to have the control and then any of these 4 criteria that we're going to run through. So the first one, you guys hopefully are following along. I think this is all on one slide in your notebook, or 2 slides in your notebook. So the amount of take is exceeded, or extent of take, if you put it in terms of habitat. So that one's pretty obvious. You've got a project that's rolling along. Hopefully you're tracking take along the way, and you get very close to the amount of take that you were authorized in the incidental take statement, and you're only 30% done with your project. What do you do then? You can go back and reinitiate. Hopefully figure out why that was, why the predictions were wrong, what went wrong in the effects analysis. Remember, we had that in the incidental take statement. I already said that. That's the reason that you would go back and the reason that you would know. Go ahead, Jerry.
One thing you can do is, like, you don't have to wait until you've exceeded it. If you've done some monitoring, you know you're getting close, go ahead and reinitiate before you exceed it. If it looks like that's the trend. And that way, no one gets in trouble. Oh, I'm sorry.
All right, so that came from the incidental take statement. To reassess basically the amount of take, we need to think about that jeopardy conclusion again. We do that through the biological opinion process, so you need to reinitiate to do that. There's sort of this logic train that we have to follow to get there. That's one of the most important things about reinitiation is you need to have a logical reason to go back and do it. And so the 4 criteria and that maintenance of control are the reasons that you would go back and do that. So this is the way essentially that you get to reinitiation. And the reason that we go back to the BO is essentially if your take's wrong, you've got to think about jeopardy. All right, second criteria, new information. I want to guess at what type of information might be relevant in this case?
Scientific.
A little louder. Scientific? Yeah, that'd be good. So what would be a scientific information that might cause you to look at the incidental take statement again?
Research, publication.
Yep.
On the species.
On what?
Habitat extent, area where they may occur, new areas.
Yeah, so some distribution information may be relevant to the project. Yeah, that's good. Occupied information. Sensitivity of the species to any of the factors, any of the things that you analyzed during the effects analysis. Those sorts of things might actually cause you to go back and say, okay, well, maybe the species is more sensitive, or even, I think from the action agency standpoint, the species are less sensitive, so we can get away with a little bit more in this case. The project won't affect that much. So that's my point by saying new information isn't all equal. Some will actually cause you to reinitiate, some won't. So if the distribution information falls well outside the action area, you don't really need to worry about it. It wouldn't cause any sort of reinitiation at all. So we sort of already described the situation, so we'll skip put in there. So number 3 here. So basically your action is modified. So you've gone in, you initially thought you were going to use, a certain type of grader to go through and do your clearing and grubbing. You want to switch that technique. Is that enough to cause reinitiation? Is it a real change in the action? Depends what?
The species,
yeah.
What their ecology is.
Yep.
If the change in the means of doing the construction disturbs the soil or the substrate in some way that the previous application or proposed method didn't.
Yes. Yeah, you guys are good. You've played this game before. So it basically for all of these, so that was my equipment example. What about this one? You want to change the types of pesticides that you're going to use. What do you think in that case? More or less than the grader? Does it depend more or depend less? It's still hard to say. It still just depends, right?
Oh, that's true.
How about the time of year?
It could be. During nesting season.
Yeah, it depends on the species again. How about the actual year that the project is implemented? So you want to delay by a year. You've got some other things that came up with your permitting process. You had to do something completely unrelated to environmental compliance, and now you've got to just delay the project a year. Is that going to matter? What's that, Joy?
I said maybe not if your permits are still valid.
Yeah. Maybe a little less in that case. The major point, but with all those examples, is it does depend on the circumstance. You just got to go back and think about your effects analysis and the analysis that you were doing, the species ecology, the actual action area, and the environmental context for all of those types of things. There's no real set and fast rule with any of those things. It depends on the analyses that you did to get to your incidental take statement and your non-jeopardy statement. All right, and then the last one is fairly common sense. A new species is listed or critical habitat is listed that affects the action area. And so that species may be within the action area, then you have to consider that in addition. We mentioned the conference process. Well, I guess the key thing is this has to actually happen before your action is completed. So the timing has to be there. So remember your window of opportunity essentially is something that we wanted to talk a little bit about. And I think this is one of the ones that kind of springs up that discussion a little bit. So especially within the Southeast region, we have a very court-mandated schedule for going through listing decisions for the next through 2023, I think, and then we have a backlog that is sitting beyond that. So we have a huge list of species. Essentially, you'll probably only have a year or two from the time you go through your compliance to start to have to consider this one popping up as a potential, depending on the distribution of the species that we're working on and your action area, I guess. The key thing is just to remember, go back and review that species list on a fairly regular basis, and then think about the critical habitats that are being designated. So watch the Federal Register, talk to Mary or Lourdes or John about the new species that we're working on. Rob.
Yeah, I just wanted to say that, you know, we've had for the last 5 years a publicly available listing plan that's in response to lawsuits that we've had, but we still have, as I mentioned yesterday, 320 additional species that that we have to do petition findings on. And right now we're working on our national plan, as Sean mentioned. That's going to be made public, you know, for everybody to see. Right now we're still working on the final touches and getting it in place. You know, we can't do all of those species at once, obviously, and the majority of them are in the southeast. So we want to make sure we have a good, you know, good scientific basis and priority system for when we go through all of those actions. But that will be available soon, so that could be helpful in your planning efforts. So you see which species are coming down the pipe. Down the shirt pipe.
Yeah, go ahead.
So we've got a PO issue for a project, and you know we let the job in construction. They're pretty receptive to construction. The new species come out. The expectation is that DOT has to identify that species and go back and reinitiate special setting consultation.
So this gets to the last point that I put up there. So think about the conference process. We mentioned that before, and so the conference process allows you to include those petition species, or those proposed species, proposed species. So once they've been proposed for listing, that gives you a 12-month window to consider them through the conference process as well. So that essentially buys you another year in terms of that. So you can go back, but technically, I think if you didn't include them in the conference process during your BO, then should have to go back if your project takes 3 years or something like that.
We can also do a conference, and we do this in intra service consultations where we consult with ourselves on our own actions, candidate species. So if one of these petition species is a candidate, we've completed the status review that says listing is warranted. You can, and that species occurs in your project area, you can request a conference opinion for that species so that work is done, you know, if a listing decision should occur before the project is completed. And I'll be talking about that in the next session.
Right.
Right.
I had several projects that went through that as a monthly listing. So we knew it was coming from the Federal Register. We knew what year it was going to be approved for the 5. Yeah, I know. Yeah. And so when we went, well, we had these conferences or these reports and coordination letters, and Mary would write it in her, you know, responses that if your project goes to construction after listing, these apply. If it's before these, you know, this applies. And so, yeah, I mean, in the cases where we knew we were going to be under construction for sure, we just went ahead and implemented whatever was going to be required for that. But, so, yeah.
I guess I think there was a comment yesterday about having all the new species are going to have critical habitats.
Yeah.
That's my understanding.
And so, and then should be a GIS database to make it easy for the applicants to know where they can go get that information.
Yeah.
There is. All the critical habitats are online already. And I think those just get updated as soon as the species is listed and goes into the Federal Register.
Just the point that this can happen at any phase of the project. We've had it happen in the PD&E. You finish the biological opinion, and new species get you have to go back and amend it. an EIS project that took several years to complete.
So, yeah, go ahead.
I'm assuming it's also true if the species is delisted, and would you reinitiate at that point also, so you can get more flexibility in the project? Like that's probably discretionary.
If you wanted to, I think is the big thing, and we'll get into that in the next couple of slides here in terms of the requests and the request process for that.
The eagle would be your example of a delisted species, but then the management plan for the eagle was still kind of restricted, so you had to still follow the management plan. So it was a little bit different, but.
If you have a species that is delisted and you've got an opinion that has terms and conditions in it for minimizing take, once the species is delisted, the prohibitions under the Act no longer apply. So incidental take is not, it can't happen. I mean, take doesn't apply to a non-listed species. So we'd sure still want you to avoid and minimize adverse effects to that species, but strictly speaking, you're not liable for incidental take that might not be in compliance with those because it's other laws would apply. Like we just delisted the Louisiana black bear. We've got BOs out there that have terms and conditions for black bears in Louisiana. That you still don't want to, take Louisiana black bears, but the endangered species, law enforcement folks are not going to bust you if you didn't do exactly what we said in those terms and conditions now.
Well, so how does the management plan explain? Does it?
Management plan?
Or like habitat conservation? Do you deal with the management plan so well?
Oh, the recovery plan.
The recovery plan, I'm sorry.
Well, what's happened when you delist is the recovery plan has accomplished its mission. Yeah. We monitor delisted species for at least 5 years, and there's still conservation plans that apply, but it's mainly to just make sure that recovered status is maintained into the future. So it's a different focus.
And one caveat on that is that that's going to vary from species to species and how the authority was transferred over. So eagles is a little different. There's the Bald and Golden Eagle Protection Act, which actually is more strict in some cases than in some senses than the Endangered Species Act. So in that case, there's a management plan that goes along with eagles and those sorts of things. So, but with bears, I think the authority is transferred over to the state of Louisiana then. And so the state may have a management plan. They have to do the monitoring, like Jerry said. That's part of the ESA. But then the state probably has a management plan that's going to have certain stipulations in it as well. And oftentimes we'll include those in the conservation recommendations in any subsequent DOs just so that, okay, so black bears were recently recovered. The state has this management plan. Here are the things that they recommend. Just as a reminder, again. And those recommendations aren't binding in this case. They're just, we recently were very concerned about this species. Here are the things that are keeping it off the list, essentially, at this point. All right, so I sort of punted on the timing thing. So we've seen the 4 criteria now. What do you think in your DOT case is actually going to pop up and be the most limiting in terms of time of your BOs being good or staying valid? Which of the 4 criteria would be most likely to cause you to come back to us and say, I think we need to reinitiate? Design changes? Okay. So you'll see some field offices put in timings. I talked a little bit with Mary and the other folks about this of, if you've gone 3 years, come back to us and talk. Those will actually be terms and conditions within in the BO. But it varies. I think the key thing is to think about those 4 criteria. Excuse me. Think about those 4 criteria, and as you go through the process and get closer and closer to construction, have we changed anything enough, or have any new species popped up that we really need to think about before we jump into this? Or as you go through the process and get closer and closer to finishing the project, where are we in terms of take?
question for you.
Yeah.
In the scenario that you had given earlier where you have a certain amount of impact and you're approaching it and you know you may have more impact than that, can you initiate and still have the contractor work up until the point at which he's at, well, or do you just have to stop everything?
So Jerry's point there is a good one, and I'm going to come back to this one in a couple of slides. But the key thing is you should be tracking take along the way. Some field offices will even put in thresholds in there, so be tracking your take. When you get to 50%, talk to us. When you get to 75%, talk to us. And the whole purpose of that is to just avoid exactly what you described, which is, oh crap, we're at 99% of the take, and we got to stop the project. You don't want to do that. Nobody wants to do that. So all the incentive in the world to talk to us on a regular basis, track that take well, and make sure that you're communicating with the service. And if you think you're getting close, we need to go out and do a site visit. Just keep that communication line open.
If you reinitiate, sort of ahead of the absolute need to do so, a request to reinitiate follows the same procedures as an initial consultation. The time frames and everything are the same. However, we recognize that reinitiation, there's usually some urgency with it, and so we'll work with you, especially if you're coming to us early, and we don't have to start from scratch. A reinitiation, usually you can limit the scope of it to what has changed, what's different, what do we know differently now, and the BO you get back from us will incorporate by reference the stuff that was in the original BO and focus on the stuff that's new and different. And we can do that. So it doesn't take us as long, usually in a reinitiation, to deal with the new information. We still have to come to and support a jeopardy or no jeopardy conclusion, and adverse mod or no adverse mod conclusion, and give you a take statement that's based on the new information. But we can do that in a streamlined, expedited way. Usually, we have the full 135 days, but if you've got a contractor that's on hold, and if you haven't exceeded the take yet, and we're just trying to accommodate some new information, it can happen faster. So, and plus, you guys are paying for liaisons that put your work, as their top priority. So you can influence those priorities.
But if you're proactive and at 85% of these cases you're authorized and now it's you say, gosh, I'm getting close. If it looks like we're going to go over, let's reinitiate. Does the project have to be on hold during that part, even though you have not exceeded the authorized amount?
No. It does not have to be on hold if you have not yet exceeded take. Most of our reinitiation statements, reinitiation notices say, if the amount or extent of take exempted in this opinion is exceeded, all activity causing such take must cease. But only the activity that's causing the take must cease. And of course, if you haven't exceeded it yet, you don't have to cease the activity. So that's why coming in ahead of that time, if you think you're headed that way, is a good idea.
For experiences I've seen in my district is you have a contractor out there working, and he can charge you every day that you're holding him up because he's already mobilized and he's already out there, and that the cost can be pretty significant. So for us to make a decision that it looks like we may or may not go over the biological opinion, we'd be real nervous to start to reinitiate if it meant that we had to stop. it would be a challenge for us, for fear that the contractor would start charging so much money.
Well, that's why I think they're suggesting we try to keep track of it more closely.
Yeah.
I mean, I know it's hard, but so you just stop more leeway to get in and talk to them about it.
Don't we have clauses in our contract to address that? I mean, that would cause the permit to also have to be modified. The contractor can't work without a permit.
But you didn't get a permit. I would say if your biggest fear is having to stop work, then come to us early.
No, that makes sense.
Yeah.
It also doesn't matter, depending on what caused the overrun of the bid. You know, if the contractor's error, then
that's true.
Absolutely, we should have some kind of clause in there that holds the contractor responsible.
Yeah, and that's a good point too. Is that if there is some sort of violation of the terms and conditions in the BO, that goes a whole other route. So you go into Section 9 at that point, and so you'd have unauthorized take at that point. So you go outside your incidental take statement authorization. So that would be, a potential scenario as well, but that would fall in a different situation than reinitiation. You'd probably reinitiate in that circumstance also because you want to go back and relook at the problems that happened during the project or the violations that happened during the project. But that would go down to Section 9.
And that's something I don't know how to do, is how to track take, on some of these species, because the take isn't a giant surgeon floating dead in the water. It's some small thing that you can't see, like a mussel that's living in the dirt, or I'm impacting the habitat, but I don't know if I'm impacting, how that's affecting the species. But so that whole, I don't know how to quantify that.
Yeah.
As construction moves forward, I just have to keep my fish and wildlife service up to date on anything that goes wrong during construction, and I'm dependent on them to tell me where I am on the take, threshold for several of the species that I have.
Yeah, it is the action agency's responsibility to monitor take through the BO process. That doesn't say that we weren't going to be involved, and especially where we have recovery leads and ongoing monitoring programs and that sort of thing, we could certainly be involved in that process. But let's talk about an example, a stream, and you've got a certain amount of habitat that was used as the take measure in there. You can track the condition of that habitat, so you're authorized for whatever, let's just say 300 meters of take during a project. You can just have a contractor or consultant out there monitor that condition of that stream periodically throughout the duration of the project, and that would be the compliance monitoring that you would need. Now, the biological results, if we have ongoing sampling for those mussels during that project as well, that's great. That's additional information on the actual occurrence of individuals. But in that case, we would have used a surrogate to measure the habitat as the measure of take in the PO. Yeah, Brian.
I just recommend that if you get a take statement, the metric used to identify whether you're going to see take has to be very clear. Something that you can make. If you can't understand what it is, so that's the service. Okay, I can understand it. Or we need a surrogate measure in this place, so that we, as holders of incident take statements, understand if we're going to see take. If this is something vague, or you have someone else does that in service all the time, that shouldn't be written. You have to make sure when you set that incident take statement in the BO that you understand what that is and how you're going to monitor it.
Yeah, and that's a great point, and that's why we use habitat a lot for stream-dwelling organisms, is that it's much easier to monitor the amount of sediment in a stream than it is to monitor the number of mussels in that stream because of detection issues. That comes up a lot with other species too, red cockaded woodpeckers and other things as well. Okay. So I want to clarify a couple other things, or at least drive home a couple points that we've already talked about in our discussions here. And then we'll jump into a little bit of a lengthy example and kind of talk through some of the reasons we may want to reinitiate in that case. So just like the first thing is, who is responsible? And I think somebody asked this question earlier. Who's responsible for reinitiating? Action agency? Could be. Anybody else want to venture a guess? Yeah, right. So, either can request to reinitiate. And this is kind of the interesting, I was going to say weird or strange, but interesting situation within our regulations in which they say you must reinitiate under these conditions. You must, you shall. That really, really strong legal term. But then they also say either agency can request it. So it's that kind of contradictory language within the Act that I think allows for either party to identify potential issues or potential changes in those core criteria, and then come back to the other and say, look, this is a really important thing. We need to come and talk about it. We potentially need to initiate the consultation for one of those four reasons. Either one. And the second point I want to drive home is, can we always do it? Can we always reinitiate? No, right. I sort of gave the answer earlier. Because if we don't have that control, then we can't reinitiate. So remember, that was the overarching, or really 5 criteria, 4 of them that we described in detail, and then that control has to be in place as kind of a given. If you don't have the control, you can't reinitiate because it's out of your hands.
So you're saying after the project's built and the permit's expired and it's been a year or so later and some failure happens?
Yeah, if the project's done and you're outside the window of time that the monitoring and the terms and conditions were valid for and all of those things, and excluding some other major event that was covered within the BO, then you're still responsible for that project, but it wouldn't be in the BO anymore. The BO would have expired. Yeah, in that place, that would probably be the best way to go about it. Or potentially it would be a Section 9 violation. But again, it depends completely on the circumstances of the project. Yeah, that would be emergency.
But in this regard, would we the shall lecture?
So the we is the either one of the parties, either one of the reinitiating parties of the 3 agencies, the action agency, the NIMPS, or the Fish and Wildlife Service.
We can suggest that reinitiation is warranted and appropriate, but we can't make you do it. That's the thing about consultation. It always requires 2 parties. The action agency is always the one that must initiate it. We can suggest it, but we can't make you. And the service is always the one to conclude it. That's the bottom line. So yeah, we can suggest it, but you have to actually request a reinitiation. Even though we say you really need to reinitiate, you could say no, but then your Section 782 compliance is then in question, and your exemption from any incidental take violations is also in question.
All right, so here's an example. Do we have control in this situation? Could we come back and reinitiate? So a federal agency, it's called the Forest Service, has a chunk of land, it's an isolated patch. They want to do a land swap. So they are disposing of this piece of land. They'll no longer have ownership of it after the disposal is done. Could we come back and reinitiate? Do we have that discretionary control still?
If it's a Park Service, maybe not.
I think I heard a mumble of no back there.
The Park Service is one of the two agencies that can do that.
Yeah, so they would be the action agency in this case. So the disposal of the land is the action that they would be doing. So they should have to come in and consult on that. That's a federal action. They're doing something to a federal lands. So there's a federal nexus there. So they should come to us and say, look, this is part of our, land management planning process. We're going through this action. We're getting rid of this 8,000 acre chunk of property, something like that. The question is, can we come back and then relook at that action if, the next owner decides to turn it into a strip mall? Yeah, right. Unless, yeah, right, okay. So, but it wouldn't be a reinitiation in that case. It would be a whole new consultation. Yeah, so that's just an example of, one of those situations in which we don't have any control over that piece of property anymore. We don't have any control over the action anymore. So that discretionary control is just gone. Yeah, go ahead.
What if it's swapped with another federal agency?
Yeah, then the other agency inherits that responsibility. So there's still the federal nexus there. Okay. So let's jump into an example and play this out a little bit more. And so this is one of my favorite, both NEPA and now formal consultation examples, since they've progressed this far in this project. So this is Cape Wind. Cape Wind, you can't really, this is awful, you can't really see this map, but this is the Cape up in like near Nantucket, Massachusetts, Boston area. So this is the Horseshoe Sound, a great area for lots of many migratory birds, those sorts of things. Also great fishing grounds, very great historical fishing grounds. A lot of the, the Perfect Storm, I think, happened right up here. The movie was in that area. So, a lot of natural resource use in the past in that area. This was also the first application for, or not the first application, the first one that's actually progressed through the permitting process for an offshore wind development in the United States. And so a couple of stats for you here on this. So the actual project's going to be located about 4.7 miles from the nearest shore. So they're out here a little ways, from out here somewhere into the ocean. They're going to put up 130 turbines. And they're going to generate enough energy to power about 3/4 of the Cape area, just with those 130 turbines. So a lot of energy is going to come out of this. All right, so a couple of questions. Who's the action agency in this case?
Is it fairly funded?
Mumble, mumble, mumble.
Is it fairly funded?
Noah? Who deals with energy issues in the federal government? Yeah, Department of Energy. You want to guess what the actual bureau within that? Kind of the name of the bureau doesn't make any sense if you're talking about renewables. So it's the Mineral Management Service.
It's Department of Interior, yeah.
Well, it's DOE too.
DOE who's the lead though? I mean, it's offshore energy leasing is what is now BOEM,
right?
The Bureau of Ocean Energy Management.
So it came back to us now, right? Interior.
Yeah.
Right. So you have energy and interior both in this case. So you've got two energy interests basically involved, two action agencies in this case. But in that case, when you end up with two action agencies, one takes the lead. BOEM, or Mineral Management Service, is who the letter's actually addressed to. So action agency, we have a federal nexus. We've got this large project. They went through the NEPA process. This started in 2001, and they haven't constructed a single turbine yet. So that gives you an idea of how long these processes take. You guys are used to road projects, so you know the duration of the stuff that happens. They looked at 17 possible alternative locations. The key things that they were thinking about, well, what would they be thinking about? What's swimming through the oceans out there? Whales, yeah, marine mammals. So you've got Marine Mammal Protection Act that comes into play. What else? Migratory birds, yeah, Migratory Bird Treaty Act comes into play. What else do you have coming into play? Got a couple migratory birds that are actually listed also. So you've got those coming into play as well. So you've got 3 federal laws. So during the NEPA process, they thought a lot about siting of those 17 different alternatives and how they could deal with placement to minimize impacts on those.
Well, I know people actually want to look at it.
Yeah, right. So it's 4.7 miles offshore. That NEPA, you have to look at all these other things too, as well as kind of some cultural issues like visual effects. You guys know that process very well. All right, let's see here. So they progressed to a point where they, for the Section 7 consultation, they were looking at roseate terns and piping plovers. So those are your listed species that you're interested, especially piping plovers. They dealt with the marine mammal issue by, I'm going to toggle to the next picture here to give you guys a nice look at this visual simulation that they put together. So you've got your turbines here, and then those things are sitting down in the water down there. They did this interesting thing, and they did a whole bunch of, this has been going since 2001, so they've done some studies looking at how these turbines affect the magnetic fields and the movements of marine mammals and fish under the water. So they have used this magnetic shielding technology, sort of like our motion detector that was come up with. These are the sorts of things you don't really think about, but then these projects drive some interesting innovation. There's a huge interest in making these things economically viable as well as commercially viable, so that you can put more of these things up, so get them through the permitting process. Yes?
About restriction of navigation, or how do people get in and out through here? They got to thread through these, or not so near them?
Yeah, that was obviously one of the citing choices during the, So the key things that they were focused on from the natural resources perspective, you can go back to that map, was not necessarily some shipping considerations, certainly, but also migratory bird paths. And so that 4.7 miles gets you outside of most of the migratory bird paths, and also gets you far enough away from the shore that many of the marine mammals aren't coming through this direct area, especially with the shielding that they did. For fishing, they actually thought it would be great because it's more structure, so the fish will hang out around those piers. At least that was their logic. They used a lot of information from the European wind farms, so Germany, the Netherlands, a lot of the EU countries have put really high targets for 80% of their energy demands coming from natural resources or from renewable resources. So wind has been a huge one. So the North Sea has many of these things. There's been a ton of research done. So they used a lot of that as the justification for doing this project. All right. So with that introduction, I basically wanted to set this out to you guys. They have a BO now. They're set to start construction sometime in 2017. So the first one of these turbines should go up, and the first pilings and things should go into the water in 2017. What are some of the things, if you were kind of sitting on the other side, or you were the action agency in this case, what would some of the things that you'd be looking for that might cause you to think about, oh man, we need to reinitiate?
Time.
Time? Okay.
Your data, is there any new information?
New information, right. Yeah, so that was one of our 4 big criteria there, new information coming in the door. So those European wind farms have been running for a while. They're doing continuous monitoring and studying on those. You've got some terms and conditions that specify you have to be monitoring marine mammals and roseate terns, piping plovers. So that certainly could come into play. What else?
If they're monitoring and they notice some disruption of normal patterns, that might trigger it also.
Yeah, exactly. And so that's, again, sort of goes along that new information pathway. What else?
Installation, how they said they were going to put these in.
Yeah.
And if they finally select a contractor and the contractor decides he's going to do it a different way because it's cheaper, how do we, but that's not what we considered when you did the CO.
Yep. Yeah, and this one's an interesting one. In this Cape Wind Associates is actually a corporation. So they're the applicant. They're also the major driver on this project. So they'll have subcontractors potentially that could go into that situation, but they are sort of maintaining control over that. But yeah, the changing in action. Yeah.
How about a new listed species?
Yeah, new listed species. That's another one.
Red knot.
The red knot.
Red knot.
Exactly. Right. Yeah. So basically, any four of the reinitiation criteria could come into play there. So this is an exciting project. I used this in my environmental policy classes when I was teaching a decade ago. So it's kind of interesting to see that they finally got through the BO process and they have their BO and they're going to be starting construction next year. When I first taught this, they said they were going to start construction in 2009. So they're only 8 years behind schedule. All right, so a couple of last questions, and we've already talked a little bit about some of these things. So you could end up in a situation where you're a little uncertain about, do I need to reinitiate or not? And we talked a little bit about this with some of those take thresholds and some of those things. I think the major point I want to just drive home is, if you're a little unsure, you guys have DOT liaisons that you're paying the salaries for, and they're supposed to be prioritizing your work. Give them a call. Give Lourdes, give Mary, give John a call, and just talk through the situation with them. The early communication and regular communication is just a real key point. And then the other thing is, so if you do make a determination or a decision that, nah, at this point in time we don't need to reinitiate, here's our logic. And the service was interested in, or at least bought off on our logic and concept. So you document that in your administrative record. And that covers your conversation, it documents the logic, and if you ever get challenged on, why didn't you initiate earlier? Well, we had this conversation. The service was on board with us, basically kind of continuing with the project for a while. All right, so I was going to have us play a little bit of a game here, but we've already played the games enough, I think. So we'll keep going. So Jerry hit on this one a little bit earlier. So this gets back to that request language in there. And so you can end up in a situation where either the services, NOAA or NIMS, or Fish and Wildlife Service, or the action agency don't want to reinitiate. So what happens then? Neither one can really force each other to do anything. There's no legal authority there to force another agency to do something. So what happens? No, yeah, nothing. Nothing is one potential option there. Yeah, that's sort of like, all right. Well, we're going to just kind of ignore this. So there are some potential implications to that one, in that if it's the action agency that doesn't want to reinitiate, if the take gets to the point where you've gone over your take allotment and the take statement, and that was the reason that the service came, or a change in the action, a modification of the action was the reason that the service came to you, you may be setting yourself up for, like Jerry indicated earlier, the Section 7 authorizations essentially disappear, and you're left with, you're under Section 9. Your take is no longer authorized. So that you lose those protections that you spent so much time going through the BO process for. So if the services come to you, it's worth giving it a listen. Same thing from our standpoint too. If you guys are concerned about changing the action, we have 3 folks that work just with DOT on this sort of stuff. We should give a listen as well. So my thing is.
So you see pay, and then just Fish and Wildlife Service have the ability to punish you, or do they have to use the core through the core process to impose fines, or that I don't know how that all works.
Could be both.
The Fish and Wildlife Service has the authority to impose fines.
Yes. We haven't talked much about the criminal aspects or the civil aspects of Section 9, but there are specified fines that can be through that. We can also require mitigation, and anything from 2 to 1 to 8 to 1, depending on your circumstance. Mitigation is there. We're in the process of revising the services mitigation policy, and so the services policy is basically you have to have a net conservation gain through mitigation, and that's been interpreted as everything from a 2 to 1, sort of like is used in a lot of wetland contexts, all the way up to an 8 to 1 for really highly impaired species. Yes?
What are some circumstances in which you would not want to reinitiate? So maybe the action agency is a little more nervous than the
than the service would be in some cases. So you come early. That's what I kind of made as my point earlier, is that if you feel like your change in action may be causing take differently or may have a different effect on the species that was originally analyzed, go to the service. They take a quick look at it and they say, this thing basically does the same thing. The species just won't be sensitive to this. So in that case, you wouldn't reinitiate. But at least you would document that in the administrative record and you would be covered that way. So that could be one circumstance. Anything else? Jerry, another one?
I think David here was talking about the main circumstances that you don't want to stop progress on your action because or you don't have the resources to, invest in a reinitiation. It requires some effort on your part. You have to provide in writing, here's the new information, here's what's changed, here's our request. That would probably be the main reluctance. Let me think. We have had some agencies refuse. I'm trying to think of the examples. An ongoing action, water management, land management, the federal action agency disagrees that whatever has changed, the new information, does not alter the findings of the BO. A difference of opinion. We don't think that we're affecting the species in a manner any different than you already considered. Sorry, we're not going to do that.
Is there any instance in which the services would not agree with it?
The we're too busy. These DOs take a lot of time. I mean, in this circumstance, that we have 3 DOT liaisons, 1 for each office. So that argument will come into play less. In other circumstances, you sort of get put queue when we have limited capacity. So that would be a circumstance where we may say, yeah, we're interested in reinitiating, but it's going to be 6 months before we can do that because we're working on XXXX. Not the best answer, and again, certainly not what we would want to use as a general policy, but that is with diminishing staff in the service, both services. That's a reality sometimes. Again, it begs more for the action agencies to keep good track of their take, keep track of their actions, keep track of the species that are being listed, and think about those changes, and think about coming to the service early so they get into that queue in some cases. Again, probably not as applicable to you guys, given that you have specific liaisons.
I don't know of any example that the service has ever refused a request for consultation. Yeah, we take it pretty seriously. I mean, it's all federal agencies' responsibility to comply with Section 7, and for them to do that, we have to do our part. I think what happens is that, like Sean was saying, it gets in the queue, and we might not, be able to honor the timelines just because of staff resource limitations.
And that's different. I agree. I would think in a situation where a service is well, you already know there's a problem. We don't want to talk about it. But because of the way that the question was phrased.
Yeah.
I think you were in your examples of the 130, where they're like, oh, we're getting done early. Let's throw 30 more. And you're like, no, we don't have time for this. We spent this much time doing this.
Yeah.
That's just for your convenience. It's not,
Yeah, I would say, would that even be reinitiation? It does change the action. To me, that would be a new action beyond the scope of the original project, because you're going to have more area affected, all of those sorts of things.
Well, what if they wanted to change their installation method for their convenience, but it was going to reinitiate or something like that? Change it. All the time,
It hits the criteria. I mean, certainly hits that would change the action criteria. Your point about we've spent so much time on this, going through the process is a good one, though, and that you would want to have that conversation with the service to make sure that maybe you could have the conversation, you could dig up some research and present it to the service and say, okay, so we agree with you, there will be no change.
I have seen it happen, and this happens fairly commonly, is that especially action agencies that don't understand the process very well, is that they will request consultation when they don't need to. They could use those optional procedures for concurrence, but they have elected to request formal consultation, and which is your option to do, but it puts more of a workload on us, and so we might try to say, hey, you could use this other optional informal process, please. So that happens, where we can't really refuse to give you a BO, but we can say, hey, by the way, maybe you didn't understand. That's happened. I've dealt with that situation several times.
Yeah, the other thing we get is a lot of requests for concurrence on no effects. And so if those come in the door, that's the action agency. You made the no effect determination. We can certainly talk to you about the details of that, and that's technical assistance, and certainly we're happy to do that. But you make the determination no effect, we don't need to agree with it. You just need to document it. All right. Let's see. So talked a little bit about concurrence. Can you reinitiate for concurrence? There's nowhere in the regs that it actually says you can reinitiate for concurrence. Sort of logic dictates otherwise. And oftentimes you'll see, or at least some field offices, so there's reinitiation language on, I think, page 60 in section 4 of the consultation handbook. If anybody downloaded that, there's a nice block that you'll see that's almost always copied and pasted straight into any BO. Some field offices will put that same paragraph minus the talk about exceeding take into their concurrence letters as well. And basically all that is a reminder to say, look, you guys have made this determination of not likely to adversely affect. We agree with that, but all this other stuff has to stay the same, everything that you described here, and if any of those other 3 criteria change, you still need to come back to us because it may change that determination that you made. And obviously there's no take because there's no incidental take statement to deal with. We've already talked about this, so I'm not going to hit that one again. We talked about that in detail. So I want to end with our little typing Clover here, and he's getting the worm early. So Dave, I'm going to go back to the point you helped me make earlier, which is come to the service early. Have discussions regularly. Lourdes, John, and Mary are very happy to give you a call, or Peter or John are happy to talk with you about these sorts of projects. And if you do think the action's going to change, you want to know what species are on the docket for the next couple of years, you may want to include as a conference, that sort of stuff. Just talk to the service. Talk to your liaison. So any questions before we shift gears and talk about requirements a little bit? All right. So we're going to talk about responsibilities of both the action agency and the services after this, after the biological opinion comes to you. And most of this is going to be about the action agency, a little bit about the service. So the federal action agency has several things that they have to do. The first thing is they have to decide if they like what's in the BO, and they're going to proceed with that. So they can disagree with those things. It just has some implications if they do. So that's the first decision that they have to make. So you get the BO, it has some, we always joke that the first thing you do is you flip through all of the analyses and you look right at the back at the incidental take statement and you say, what are the RPMs, what are the terms and conditions, what are the things that we actually have to do, how much take did they give us? So those are the things that you really have to make the decision. Do those terms and conditions make sense to us? Are we going to be able to implement them? Like Brian made the point earlier, does the way that they are tracking take or allocated take to us make sense? Are we going to be able to actually monitor that? So you have to think about those things to make sure that you can implement the BO fully throughout the duration of the project. Brian.
I just want to point out to the description of the action, when you're DA and when it's a DO, you have to make sure that's correct. Because that description is what you're supposed to. So if there's some transformation in what you did or you didn't spell out now what you're asking to do, then that can lead to reinitiation. If you're saying things that aren't true, and you think maybe something that's not true, or you let that thing there occur, then the services are every right to say, hey, we haven't considered the project. So that project description part is really important. I know we all jump to the back, right? The end of these things, and look, which is also very important, but that description is just as important.
Yeah. Yeah, and that's why it's important to look through the whole thing. It's not only the description of the action, but also the analysis that we did on that to make sure that you agree with how we approached that analysis. Because in some cases, we don't have all the information we want. So you're stuck making some hopefully logical jumps, but you need to make sure you agree with those as well.
I had that happen to me on a project. DOT inherited a project from another, you know, we have these transportation authorities that get set up in the system that aren't really DOT, they're something else. And some of them, we were going to implement their SEER, and the way they described the construction of the bridge wasn't a way we could see doing it. Top-down construction was proposed, and some other details that were described in the action were not what we could do. And some other things to talk about how it was describing the road as a limited access road, and we weren't going to build a limited access road. We would build it, you know, to some access restrictions, but not that limited. So we had to go back, and or we're going back and spending a lot of time reevaluating that impact.
Yeah. Yeah, again, goes back to Brian's point, and also one of the ones that I made in the first lecture from Tuesday, if we remember back that far, is make sure that you understand the language that's in that, and you understand the kind of the way in which you can implement that. Is it within your legal authority to do so? Is it within your kind of capacity authority to do so as well? So that, again, goes back to take a very close read on what's in the BO and make sure that you can do it. All right. Hopefully you've gotten to this point and there's nothing to deal with. Communication, again, make sure that you're communicating. A lot of cases we'll share drafts of BOs with folks to make sure that there's no surprises there. We'll have conversations about some of those drafts, those sorts of things. Again, it's that communication and coordination aspect. I go back to what Jerry said on the very first day, is that the name of Section 7 is actually interagency coordination, not consultation. So that's the key language in there. So coordinate. So hopefully no surprises there, but you know, you can always go down the path of ignoring those RPMs and terms and conditions, but you just could end up in the Section 9 realm then. So it's a dangerous path to go down. All right, the other thing that action agency has to do is they must notify the services if the final decision of their decision on the action. They have to decide if they're going to accept this. And if the jeopardy opinion, you have to tell us the reasonable, prudent alternative. So remember, you get reasonable, prudent measures in an incidental take statement. With the jeopardy opinion, you get reasonable and prudent alternatives. So you have to decide which one of those alternatives you want to take, and you're deferring that. So if you ever get a jeopardy opinion, and this happens very, 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 very infrequently, and they usually end up at Jerry's desk when they do. There's different processes that you have to follow, and in that case, there's going to be lots of other help around. So you know, legal help and that sort of stuff that we can talk certainly among us and the folks in the room, but usually it will get elevated to Jerry and other folks like regional solicitors and that sort of thing to help out to make sure we're all complying with the law at that point. Stole my own thunder there with the slides. So you can always disagree with the BO and proceed with the proposed action. Again, you go back to that Section 9 problem of we can come after you for civil, criminal, and mitigation violations or measures there as well. You can just walk away. You've invested a ton of time in permitting and planning, but it's been mostly a paperwork exercise thus far, so there's no actual on-the-ground stuff that's been done. You can modify the action to reinitiate. So you can come back, you can think about that, the reasonable prudent alternatives, decide that maybe you like tweaking one of those a little bit, and reinitiate on the consultation saying we're going to do this alternative, but we're going to do a few other things as well, hopefully get the, minimize or avoid the impacts even a little bit better or mitigate for them. Or the last thing is you can apply for an exemption. So we talked about this Endangered Species Act committee a little bit, the God Squad, as John called it. And so there is an exemption process. It was added with the 1978 revisions to the Endangered Species Act, sparked by the Tellico Dam and snail darter controversy that you guys probably all remember from college. So that was the big thing that sparked it. That actually wasn't one of the projects exempted. It was the one that spurred everything. But they actually sent that one back and said, look, do this other stuff in addition. They got to go forward with the project, but they had to follow a reasonable alternative, essentially. This is the only one that's been truly exempted out of the process. And it's a reservoir out in Wyoming, and it was built for this lake, and so essentially the reservoir was built for that power plant. And this gave Jerry your first job, or one of your first jobs?
Yeah.
So Jerry's fortunate that that was exempted.
I worked for, there was a settlement that came out of this that set up a trust called the Platte River Critical Habitat Maintenance Trust. I worked for them for 5 years in Nebraska. After having worked as a GS5 biotech for the Fish and Wildlife Service in the same town for 2 years. But yeah, it set up the settlement was like a $7 million put into a trust to manage the habitat to basically offset the impacts of this project. It was going to contribute to the transformation of the channel morphology hundreds of miles downstream in Nebraska. It's been called the case of the shrinking channels. The Platte River was the one that the settlers, migrated to the Oregon Trail passed along the Platte River, and it was called a mile wide and an inch deep. And birds loved that, including whooping cranes and sandhill cranes and lots of migratory waterfowl. They roost in the shallow river, and it provides security from predators, and it was a great ecosystem for birds. But with all of the western water use, those channels became a braided jungle of little islands with willows and cottonwoods. And it was transforming. It was becoming no longer suitable habitat for lots of species, including the whooping cranes, which is why that project got a Jeopardy opinion. And I can't remember if there was an RPA, but they applied for an exemption. I guess they got one. But then there was a settlement, a court settlement. I guess there was a lawsuit, and that created the trust. A few years later, I went to work for them.
Yeah, and that's good. That leads into the next thing that I wanted to talk about here. So this is the actual language that kind of goes as a part of the section. This is section 7G1, so we've been talking about 7A2 and 7A1 a lot. So there's another section, or several other sections to this, 7G1. And basically, it's the application process for all of this. And it puts a couple stipulations on here. What I wanted to do a little bit more was delve into what this committee actually is. And so it's a very high-level committee. It's mostly cabinet members, governors, and that sort of folks. So this is one of those things that you would certainly be under FACA. You would certainly have to follow all sorts of interesting rules and processes in place, and it could be a very political process. And there's been a couple instances where the committee's made a decision and then they've gotten sued in court, so there's been other stipulations that have come out as in addition to what the decision that the committee made. But I mainly wanted to make the point that this is a very high-level committee when it is actually implemented. Through 2009, it has only been implemented in 6 times. They've given 1 exemption, the one that gave Jerry his second job, and then 1 partial exemption. So they required a lot of mitigation in that point, in that case, and then they sent the other 4 back. There was a very, very recent issue on Delta Smelt, California, Sacramento, San Francisco Bay Area, and Delta Smelt and water use out there. That has not, at least as of yet, made it to the committee that they're talking about, and Congress is talking about potentially implementing the committee in that case. There's a lot of that talk that goes on before it actually gets implemented. Okay, so basically, once you decide to go in and go forward with the BO, you've got to take pay special attention. This is why I made the semi-joke earlier that people usually flip to the back and look straight to the reasonable prudent measures in the terms and conditions, because that's what you have to comply with. It usually looks for the taken. So just drive that home again. And I put the picture of the guy monitoring in there because sometimes you'll have that monitoring. That monitoring is always, you have to monitor the amount of take that you have. And Joy's point's a good one in that you have to know what take actually means and be able to do it. So it's important to be able to understand that and understand the commitments that you're making through that process. So let's switch to the other kind of side. So we've talked mostly about the action agency. The last couple slides here before we take our break are about the services. And so the services are supposed to get reports, and you guys as the action agency are supposed to give us reports on, you know, the amount of take that's happening. And these will be specified differently in different BOs, but there's usually a time scale in there, once a year, quarterly reports, those sorts of things. Yes?
Sometimes there's the reporting requirement and sometimes not. Should we report anyway? I mean,
I'm going to defer to the 3 liaisons in the back there on how they want to approach that.
Coming.
Occasionally, we probably should do a better job at that.
All right.
That report comes to or from the action agency itself.
Yep.
So that reporting that you're doing should probably at least come to Federal Highways until you act to Federal Highways.
And Katasha and I had a little bit of a conversation about this yesterday, and I'll basically mimic what the guys in the back said there, which is a lot of times we don't get the reports. A lot of times we don't actually specify them in the BOs, at least here. Other projects and other places, they'll ask for, you know, reports at these dates or at this point in time during the project, very specifically. On our end, we, you know, there are some benefits to you guys to do that. We get the most up-to-date information. We get some updates on the status of the species, those sorts of things. But we have a hard time of managing all that data. So I'll kind of say the same thing that I said to Katasha the other day, which is the service is in the process now of thinking about how we do our inventory and monitoring and how we manage our data and that sort of stuff. So there will be some changes over the next probably 10 years time frame. The refuge system is on the very early forefront of figuring that stuff out. And you now have a handbook that specifies all of the things that should go into monitoring protocols and thinking about how to manage data and that sort of stuff. And that's available online if you just Google Fish and Wildlife Service inventory and monitoring, or I think it's how to develop survey protocols. But data management is another thing. So the key question that Katasha asked was, how should we be collecting and how should we be sharing it with you? So we use FNA to manage most of our data. So they have data standards that they use to put into their databases. Given that they're a state affiliated organization, I would say that would make things easier on y'all to be able to comply with their standards and share data with us under their standards. So that's probably about as far as we've gotten at this point to answering that question. But physical reports are typically what's talked about. So progress of the action and the take generally in any sort of terms and conditions, things that were applied. Yeah, Joe.
To add what you're saying, there's the federal government seems to be catching up to the private sector and has got a tendency currently to look at performance measures and performance levels. So those reports may go a long way. The data also goes a long way to tracking performance, see how we're doing in our jobs and our progress. So yeah, the reports should at least electronically probably be passed on so they can track.
Yep. Yeah, and go back to that circumstance that we talked a little bit about earlier, where there are multiple action agencies, or in this case, some delegated authorities. So you have to keep everybody that's involved with the project in the loop there, and I think that's one of Joe's points.
Well, I'd like to make a point about the monitoring and reporting. Monitoring is sometimes needed to implement an RPM. You need information to inform the measure that's going to minimize the take. Like, you will do something when certain conditions are happening, and you need to monitor those conditions. And we should specify in the take statement any kind of monitoring and reporting requirements. And they should all be related to either, measures that will minimize take or reporting the extent or amount of take. If you don't do those, you're not in compliance with your take statement, and you're not really covered for the incidental taking. It's exempted when you are in compliance with the terms and conditions. So take it seriously. We're not, following up and making sure, it's time for that report on that project, because we got lots of other stuff to do. But just be aware that those are part of your exemption, and you need to do them. So if you think we're being excessive with what we're asking you to do, then tell us, and we'll get it reasonable. I mean, they are called reasonable and prudent measures. But we don't ask you to do stuff just, to make work for you. There's a reason for it, and but we're not really good about following up on it if you don't do your part. And so, I mean, we'll all get good at it the first time when someone files a lawsuit against you. You did all of this stuff that took listed species that required you to do this monitoring and reporting that you never did. So that was illegal take. When that lawsuit happens, then we'll get better about this.
What is that? Maybe clarify. Does every biological opinion require post-opinion reports?
If there is any taking exempted, monitoring and reporting the amount or extent of take is yes. That will always determine condition if there is take exempted. You may not have any others because you've already proposed such a great action. You've done everything that we think is reasonable to minimize the impacts. But there will always be that one.
All right, so that's a good transition. I wanted to end with 2 incentives for you guys to give us those reports, and then we're back almost right on track, so we can take a break. So those 2 incentives are just simply, we have to incorporate those results that you give us in the reports, and that's why Katasha and I had that conversation about formats of data and formats of reports and that sort of stuff, and the best way to share that information with us and make sure we actually try and do this update. But we incorporated that into the status of the species section, and that's beneficial to you guys because we use that information in future consultations. So that's the big incentive. So we understand what has been the previous effects on the status of the species and the direction that we can go, so that when we're making that jeopardy determination, the amount of take that happens to a new project, we understand what happened better with the old projects. And then the last one is just simply, we're happy to talk about those BOs. You guys have 5 liaisons now to talk to you. So by all means, use them, have the conversations with them. We're happy to do that. And not only about the existing BO that's maybe in action or just finished, but also the next one that's coming up. So that, I said I was a herp guy, so I'll end with that, is all I really have. Just remember that when you get the BO, you as the action agency have quite a bit to do, quite a bit to think about. So just look to the back of the document and look at the terms and conditions and make sure that they're or argue about those things. Look at the whole thing, look at the effects analysis, look at the description of the action, and then we have some things to do as well. So that's it. I think we have 15 minutes here, so back at 10:05, and we're right back on schedule. Thank you guys for all the questions and participation. That was great.
Okay. This module is on different types of consultations. You probably won't encounter some of these ever, or very seldom, but a couple of them you probably will. Namely the first one and the last one, conferences and emergency consultations. These variations in the middle of this list here, early consultation, intra-service, you'll never do that because you're not the service. You're not going to do national consultations. You may do streamlined consultations, but I'll describe what each of those are. And Mary will do the emergency session at the end, based on some experience, examples with Florida stuff and transportation. Conference there's a section in the regs that's explicitly about a conference for proposed species. I can't remember which one it is now. It's very brief, but it's very clear. Our handbook chapter on this topic, on the other hand, is not very clear. In fact, it's confused a lot of people. So I'm going to try to undo some of the confusion that is out there about what conferences are. And conference, it's weird to use conference as a verb, but we do. The definition in the regulations, a conference is informal discussions between a federal agency and one of the services regarding the impact of an action on species that are proposed for listing. There's been a Federal Register notice published that we are proposing this species to be added as a threatened species, or an endangered. And the same for critical habitat. We are proposing to designate these areas as critical habitat for this species. And often those will happen simultaneously. A proposed listing is accompanied by a proposed critical habitat designation. But sometimes, because there's a lot more work involved in the critical habitat designation, it will happen maybe later at some point. And sometimes we determine that critical habitat is not necessary, or it's not determinable. We really can't map the areas that contain those features. Rob?
Or that it's not prudent to the species, like the Miami blue butterfly.
Yeah.
You want to release where the locations of that butterfly are to collectors.
Those are the two circumstances in which we should not designate critical habitat. It's either not determinable or it's not prudent. So when those rules are out there, and they're usually published, and then there's generally about a year between proposal and final decision on that proposal. And during that window is when this conference process applies. It is required when an action is likely to jeopardize the continued existence of a proposed species or adversely modify. And you remember the definitions of those, you know, appreciably reduce the likelihood of survival, or appreciably diminish the ability of the habitat to perform its conservation role. And that's the only circumstance in which the action agency makes that determination. That's in consultation, those are the determinations that are reserved to the service in an opinion. But in the case of a proposed species, you get to make that decision. So it's kind of important for you to understand how do you do that? What are the standards that apply? And not very many action agencies are accustomed to doing that. So we will help you, but it is your call. Conference procedures, the federal agency initiates the conference, but as with other, like reinitiation, we can suggest one to you. We can request it. A conference can follow the same procedures for formal consultation and include an incidental take statement, even though take of proposed species is not prohibited. They are not yet protected. But we can give you sort of an upfront opinion and take statement that that we can adopt later, and I'll get to that here as one of the later bullets. I'm getting ahead of myself. You can combine a conference with a formal consultation. You've got an action, a species is proposed. You're already going to consult with us for some other species or habitats that are already listed or designated, and then we've got this proposal. So you can combine those together, and we can, if we go this formal, follow the procedures for formal consultation with the conference, we can put that in the biological opinion, and we'll call it, it'll have its own little section called conference opinion. And then later, when and if that species or habitat is listed, we can confirm that opinion upon your request to do so as a biological opinion. So you're done. There are some processes to go through to make that happen. We have to then see, well, how much time has elapsed? Has something changed? So you kind of have to do a check-in. Is that conference opinion still accurate? Do we need to do anything with it? If it's been a short time, probably yes, and then you're done. You don't have to then request consultation because you've already done a conference that looked like a consultation. We can also do the same for informal consultations for proposed species. If you say, we want to follow the procedures for regular listed species, can you give us a conference concurrence that we can then, when the species is listed, adopt? In fact, some of our offices even say, yeah, we'll concur up front that this is not likely to adversely affect this species. And you don't have to do an opinion for a concurrence. And that's good so long as the action doesn't change. And we don't get it. The 3 of the 4 reinitiation criteria apply. One different thing about conferences than regular consultation is once you initiate a conference, the 7D of the Act does not apply because those species aren't listed yet. They're not protected. 7D is that once you initiate consultation, you can't make any irreversible or irretrievable commitments, and that would preclude formulating a reasonable and prudent alternative, avoiding jeopardy. Well, those rules don't apply yet, so 7D doesn't apply. This flowchart there's a flow chart in our handbook on conferencing that I suggest if you get the copy of the handbook, you just tear it out and burn it. It is so confusing, and it is not really accurate. It's not consistent with our regs. And I'm not the only one to recognize this. We've known this for a while, and our handbook is way overdue for some updates and revisions. But this one is consistent with the regs. My counterparts in other regions have produced things similar to it, but get into a little more detail, like the nuances of concurrence with a proposed species, concurrence not likely to adversely affect. But this is the conference process, and the highlighted boxes, the yellow boxes, that's the only required pathway under the regs. You determine your effects of an action that's in the planning stages to a proposed species. It can also be a candidate species if you want to. And if you determine, using the logic that we've given you and how we do BOs, that you're likely to jeopardize the continued existence of that proposed species or adversely modify the conservation value of that proposed critical habitat, you must initiate a conference with the service. All of these other pathways are discretionary. You get to choose. So the other pathways, no effect, obviously nothing. If you determine no effect, no conference is necessary. If you determine may affect, you may request a conference, and then you may request that we follow the formal consultation procedures, in which case you get a conference opinion that we can adopt later as a biological opinion. Or if you don't request that formal process, you'll get what we call a conference report. It just summarizes the recommendations we're giving to you, to avoid and minimize adverse effects of the species and do good things with them. This pathway, let's see, we can make a jeopardy call up front and say, we want to do a conference with you. But you have to agree. Even though we request it, you have to agree to do that. And then again, this is a mutual agreement. Are we going to use the formal consultation procedures? But this is accurate. This is consistent with the regs. And if you read the regs on conferences, I think it's 402, I want to say 12 or 11. But it's only like, one or two columns of text, in a Federal Register format or CFR format. But this is what it says. This is what conferencing is about. One last word on on conferences. It's a good idea to say we have a may affect situation. We want to follow. We don't think we've got a jeopardy. We're not required to do a conference, but we would like to include this species or this proposed critical habitat in our consultation, and we want to follow the same formal process because we want to adopt those findings when and if the final decision is yes, we're going to list, yes, we're going to designate. It will expedite the process later on, because if you don't do that and you elect to just, well, they're not protected yet, we don't have to do anything. When that species is listed and your action is still in progress, you will then be required to comply with Section 7 for that species. One of the reinitiation criteria, a new species is listed or a new habitat is designated, then will apply to your project. And you have not complied with Section 7. You will have an action in progress, and it will get slowed up because you'll probably want to comply. And then, you know, it's the time frames that apply to all consultations will then apply to that new species.
I just want to reiterate what you just said is a good idea. It's basically Federal Highways practice. We ask you to do that and, for all projects. There are some exceptions we've encountered in saying, hey, this really isn't practical to do here. It really doesn't make sense to do it this time. But for proposed species, we ask you to do the conference process and either get a concurrent or a VO, whatever is necessary.
Any questions on conferences, you know, dealing with proposed species and critical habitats? And you can also do this for candidates. I mean, when you get a species list from us, we'll tell you, here's all the proposed candidates and listed species in your area. We internally do conferences on candidates with ourselves when the service has an action. The main thing is that somewhere out there, we need to have a status review of the species that you want to make a request for. And if it's a candidate, we have done that. If it's a proposed species, we have done that. If it's a petition species, we are in the process of doing that. So I would not advise you to request, well, I would not advise our field offices to accept a request to do a conference on a petition species, because how do you do the jeopardy standard if you don't know what the status of that species is? Is it in danger of becoming extinct, or is it, you know, likely to become endangered in the foreseeable future? Because all of the logic of Section 7 applies to those definitions. And if we don't have a status review that says where a species falls on that spectrum, we can't really do what we're supposed to do. It would be meaningless to give you yeah, we don't think this is going to jeopardize this species that we have no idea what its status is. But we can do it for candidates and for proposed. Early consultation, this is, I've never been involved in one of these. It is a process requested by a federal agency on behalf of a prospective applicant. Say someone who needs a federal permit or license is really wanting to get ahead of the game and get consultation on something that's in the works before the federal agency would do its thing, like before the Corps would issue the public notice and before the Corps would request consultation with us. It produces what we call a preliminary biological opinion. Oh, that's all I got. I got just one slide on this, is because no one ever uses it. It's like it's all of the work of actual consultation, and then you've got a preliminary biological opinion that the reason you did this is because there's probably going to be a lot of time before you get around to doing the real deal, and so much can change in that time that you're going to have to start over anyway. What's the point?
I'm just curious, that sounds like something that would be good for PE versus a full-blown PO, and PE that we know is going to change to progress to the design.
Yeah, it has to involve an applicant. If you guys are assuming, you know, the federal agency role, you're no longer an applicant. You're not really an applicant even now with federal highways. Yeah, I don't think it applies. I don't think you would ever use the FDOT projects would ever use this. You can look into it. I'm not an expert on it. As I said, I've never done one of these. Question?
I'm wondering, just to tag on, would this be used in order to prove reasonable assurance in the process? Early consultation, coming up with some type of opinion at the end that would support that we're not going to have an impact on the species, but we'll get back to it later.
I suppose. I'm wondering whether or not just reinitiating a consultation would accomplish the same thing. I don't know. If you want to investigate this process, I mean, I can do so and see if it might apply, but
there's a reasonable aversion of doing the work twice.
Yeah.
It's very reasonable, but there's also
the effects for
a request to know what's happening to the effects on the species before we close the process.
Yeah.
It seems like this might be a route that could be used.
versus maybe doing surveys multiple times.
Exactly. So like for early consultation, would a skink survey be required?
A preliminary biological opinion it follows the same procedures as an actual biological opinion. So, and all of the standards are the same, but it has no effect. It's not. You can't use that to demonstrate compliance. There has to go through another step to confirm it as a final opinion.
No jeopardy.
Yeah, yeah. You would, but you have to. Between the time that you issue a preliminary BO and when you decide whether it's a BO for that action, I mean, if it's a short amount of time, there's no sense. Just do a real opinion. If it's a long amount of time, there's so much time elapsed that you're going to have to re-look at a lot of stuff and how the action has changed and how its effects on species may have changed, and are there new listed species, et cetera. And I don't know if the juice is worth the squeeze.
So in ACDM, they wouldn't tell you they want a skate survey? PD process, they wouldn't tell you they want a skate survey?
Well, I think the problem is that now that I understand is federal highways requiring formal consultation or PD. And so we're having to basically do Joe's and Tammy.
Well,
to get effects.
I think that's because we're having to do, again, surveys twice. How do we avoid that? Is this an avenue to do that?
And it goes to the level of use. So if you do something, it's a good discussion. Okay, with early consultation, we would be able to do a mapping level of detail without necessarily a level of detail for the schemes.
Well, the first thing you have to get past is the idea of an applicant, and I mean, this is set up for non-federal applicants for a federal, permit or license, and it, like I said, I really encourage you all, I've given you the link to our Section 7 Consultation Handbook at the end of your notebooks. You'll you'll see a cover page of the Act with a link and the cover page of the handbook with a link. Download that handbook if you're interested in this. There is a chapter on early consultation. And get back to me if you think that it might have some utility for what you're doing, if there's certain circumstances, and we'll look into it. As I said, I've never done one. And everything I hear is that no one ever does them because they're not very useful. I'm going to move on. In-trust service consultation, this is when we consult with ourselves and on our own actions. Obviously, not much relevance to this audience. National consultations. I will talk a little bit about these because some of these affect what you do, but you will never yourselves be the party to a national consultation. And these are actions that, may affect things on a big scale. Many species overall are a substantial part of the country. Examples and I end up working with these a lot because, in a regional position, as liaison between headquarters staff who are doing these things and our field staff who might need to inform them. So I'm aware of a bunch of them some that are going on now. EPA pesticide consultations. This is one that's EPA was sued for failure to comply with the ESA and registering. Pardon?
What year?
Oh, many years ago.
Right.
Yeah, and they settled, and the settlement involves, yes, we will do consultation on these. I mean, it's stuff like malathion and chlorpyrifos, and I mean things that are used in agriculture and and home and garden use like everywhere. And so this consultation, literally, the scope is almost all listed species in the country. Have the potential to affect these, all listed species. So it's a humongous consultation, and we're having to, invent lots of efficiencies just to deal with the sheer volume of it. Aquatic life criteria for water quality standards. You indirectly, are affected by those because those form the sort of the default for state-adopted water quality standards under the Clean Water Act. Those have kind of stalled. There's few of them have actually been completed because they're so difficult, and then we have the nationwide permits that the Corps administers. We do sometimes we do programmatic consultations on that. It seems like I'm never quite clear on the status of those. And then Forest Service, like we're doing one, or we're reinitiating one on the use of fire retardants throughout the country now.
Are you doing consultation on genetically modified organisms?
Not nationwide that I'm aware of. We did one on our own refuges, use of genetically modified crops on refuges, and we elected in the end to not use them anymore. So that was the outcome of that decision, and so we didn't complete the
determination. You just removed the plant.
Yeah, we just decided, we elected not to use them. Recently, USDA has announced a proposal to do a sort of a pilot test with genetically modified mosquitoes that carry the Zika virus in Florida, and it involves releasing these animals that have this sort of death gene built into them, and they for the larva, and they mate with the local females. This is Aedes aegyptus. It's an exotic, from the old world mosquito, one of 4 mosquitoes that carries human-borne diseases. But it's established itself in the Southeast, including Florida. And so they're going to release this. They made a determination, no effect. So we ended up not consulting on it. And you know, it's not up to us. I'm not disputing it or saying that it was wrong, but we didn't consult on that one.
This is
Yeah.
sort of a weird squirrel, but I've heard from friends in mosquito control districts that male mosquitoes are actually responsible for most of our pollination, not bees.
Really?
What was it?
Male mosquitoes?
Male mosquitoes.
That was one of the things we recommended, is that, hey, do some studies on this release and how that affects. I mean, in the area where they release the males, it has the potential to effectively eliminate the next generation. You know, it's like if they release enough of them and they breed with enough of the females, all of their offspring will die. And then you've got that much reduction in that species population.
This directly affects bats.
Yeah, but how does that affect the ecosystem? I mean, I know it's an exotic species, but interesting questions. But yeah, I have not actually been involved in any GMO consultations other than that one, which didn't actually become a consultation. And the refuges thing with crops, where we decided we weren't going to use them anymore. I think we just decided the hassle was just, the controversy wasn't worth it. The juice wasn't worth the squeeze. Streamlined consultations. These are this is kind of a hodgepodge of thing. But you know, we have a record. We have done agency-specific agreements, wherein we have some procedures where we're going to consult with you on a bunch of actions, and we come up with a memorandum of agreement. And usually it's because there's so many of these actions and they're so like high priority that we want to get the consultation process really integrated with other processes so that these things can happen on a schedule. It's like, you know, major priority for the current administration. And most of these involve the cases where we've come up with these streamlined procedures involve federal land management. And we specify, you know, all right, we're gonna have these many people work on this stuff and these many. It's complicated. I'm not aware of any of these type of MOAs in Florida, but what we do instead are programmatic consultations, in which we can get some of the same results. Alternative consultation procedures. These are, you know, for special circumstances. And we've done these, you know, for a single consultation or for a series. Usually it involves redefining the timelines because there's some urgency, and can arrange for transfer funding in order to you know, accommodate that urgency, and adopt it again through some kind of instrument, you know, memorandum of agreement. So we are flexible. We will work with you. I think the arrangement we have with Florida DOT and the liaisons is a good one. What you get out of that is very early heads up from us on potential concerns. And I think now with, you know, dedicating at least one of the liaisons to looking at the bigger picture and programmatics, we'll be able to get some of the benefits of, you know, faster and more predictable consultation outcomes. And Mary is now going to talk to you about emergency consultation procedures, unless there's any questions about all of those other things. Good.
One thing on programmatic, and NIPS isn't here, but working nationally with NIPS on programmatic consultation. Northwest NIPS has worked with us for a long time with programmatic. Because Northeast and Southeast have been much more reluctant as regions. I was just reported the other day that their regional administrators met, and they said now they're on board with trying to push ESA programmatic consultation. So something on you have, time on.
And that is the next and last presentation is on programmatics. So after we do emergencies, we'll do programmatics, and then we're out of here.
Okay, emergency consultations. It's sort of timely since hurricane season's coming up in a couple of weeks. How many of you have had to go through a hurricane in Florida? And you know what a mess it can be afterwards. And is there time to just spend 135 days working on a biological opinion? Yeah, no. And because of that, we have some special measures in place to try and streamline that process. So the definition of an emergency. An emergency is a situation involving an act of God, disasters, casualties, national defense, or security emergencies, and include response activities that must be taken to prevent imminent loss of human life or property. So the key word there is your response activities. That's what we would be consulting on with an emergency consultation. So an emergency is not, uh-oh, I forgot to do my Section 7 consultation, and we're going to construction next week. Examples of emergency consultations. It's the repairs made during and immediately following a disaster to restore that essential traffic and protect human life and property. We're never going to stand in the way of a response that could, impact people or property. Things that are not considered an emergency, if it's a routine maintenance repair on a roadway due to buildup of deterioration, that's not an emergency. Or permanent repairs. You go in right after your storm and you get the road functional again, but usually there's another step to that planning to come up with your permanent repairs to that roadway. So the first one is emergency. Second one, we've got time to plan. So an emergency is not an exemption from your responsibilities under Section 7. It's just a expedited process to go through. Again, it's outlined in your in the handbook, which I guess Jerry has at the back of your information. So it's that emergency consultation procedures. And there is one rare exception to the ESA during an emergency, and this is something that's in presidentially declared disaster areas. I guess the president has to determine that it's just not practical to go through our normal procedures, even the emergency consultation procedures, and that's only in these declared disaster areas. It's for federal roads or basically public facilities.
Yeah, I would have to pull that out. I look at it so infrequently, I don't remember.
Yeah, and it's only to replace back to your pre-existing condition. It's not to make any major changes to it. And I don't know how often that's been done, or if it's been done maybe after a situation like Katrina where, communication is just down. That might be an instance where you'd have that exemption. So you've got your emergency, you go ahead, you begin your repairs. But you contact the service as fast as you can, by phone, email. So it gives us a period of time to at least advise you, make some recommendations on what you could do to reduce impacts during that process. Usually we try to get our recommendations out within 48 hours. And there is a requirement for post-emergency follow-up. You're supposed to be documenting the avoidance and minimization measures that you're taking, and that should include a determination of effect. And if it is likely to adversely affect, this is one instance where we actually do an after-the-fact formal consultation. An after-the-fact biological opinion. So with an emergency, the best thing to do is to do as much advanced planning as possible. You know, after we had all those storms in 2004, 5, 6, we did come up with sort of a set guidance so that we basically said for going out and doing your initial cleanup of that road, you follow these measures, you don't have to coordinate with us any further. And then we gave further guidance for as you proceed in your restoration process, just sort of standard measures that are designed to minimize habitat, just to give us a guidance, but you're still supposed to come back and coordinate with us for guidance on any particular species. So we have that guidance posted on our website, and I don't know, is everybody familiar with that? We do an update on it last year. And we have hurricanes every 10 years, so we'll do. We also have a statewide consultation with FEMA that's come up with a lot of BMPs for when you're doing your emergency repair work. That's also on our website. I think they're in the process of updating that. Is that right, Sean? Okay.
There's 2 of them. They're in the process of updating one.
Okay. So as part of advanced planning, you know your points of contact, so you know who to contact within the service. That's another thing where ETDM is great because you know who you need to call. And then we need to take a little responsibility too that when it's hurricane season, usually it's a slow-moving disaster coming. So if we know we're not going to be there, we want to make sure there's someone behind us that can take our place and get you the advice that you need. And in advance of hurricane season, check our website, have that guideline printed out. And also really know your resources. We tend to have impacts in the same areas, your coastal areas again and again. For floods, tends to be a lot of the same roads that have flood problems. So know your area, know your roads, and have an idea of what your resources are for those areas. And I guess this is basically be prepared, have your Band-Aids, and then just hope that we dodge the bullet. Any questions?
I want to reiterate something Mary said. During these emergency response actions, we are not at all going to stand in your way. You need to do what you need to do. Contact us. We'll give you our best advice as how you can, avoid and minimize adverse effects from the response actions. Not the emergency has its own impacts. The flood, the hurricane, whatever. It's the things that we do in response to that we'll want to talk to you about, and we'll give you our best shot at what we think you need to do. In the advanced planning, we get certain kinds of emergencies routinely. It's good to have guidance ahead of time. When we have these certain kinds of emergencies, these are the kinds of things we're going to have to do. Like have a list of BMPs that you will apply for the cleanup activities, for whatever. If we can talk before the emergencies happen about what those things are and what are the most likely intersection with sole circumstance in which we
our reimbursement, our federal reimbursement.
I think we're at the end. Well, what is a programmatic or other basis? How we can define a programmatic. Federal land and resource management plans. These are the big, guidance documents that govern projects, for the next 10 years for a chunk of federal lands. Routine actions that have similar effects, these keys we've done with the Corps of Engineers, how many hundreds of 404 permits do they do that are really pretty much the same. We've consulted with them on those advanced effects determination. again, actions taken under a particular authority that affect a particular species or group of species. So why would you want to do one of these things like we don't have enough work, doing all the project consultations? Why do one that's essentially discretionary? Most programmatics are discretionary. They don't have to be done. Some of the federal land management plans do have to be done. They have been told, you shall consult with the service on your, forest plans. But we ourselves don't consult with ourselves on our National Wildlife Refuge CCPs, our comprehensive conservation plans, which are essentially equivalent documents to a forest plan. But we haven't been mandated to do so, and so we usually don't, because we need to consult more at the project level, and plus, we manage our refuges expressly for the benefit of listed species. We wanted to limit our workload to those circumstances where, we're dealing with adverse effects, potentially. So you would want to do one to save time, to save money, to improve the outcomes. A programmatic can simplify 782 compliance for both of us, services and the action agencies. And because you're designing a program, it facilitates cooperation because we start thinking about the bigger picture. It can also facilitate, make monitoring easier. We were talking about this after the last discussion on monitoring in reinitiation and what do you have to report. Programmatics can establish that framework for a bunch of projects, how they're going to do the monitoring and what kind of information they'll collect, and it will all go to this place, to these people. And so sort of eliminate that ad hoc, chaos of figuring it out each time on a project. But the real incentive for us as a Fish and Wildlife Service, and for you, I hope, is that by doing things on a program basis, we can get better conservation outcomes. We can look at that bigger picture and say, hey, for this class of actions or for this species, we're going to be on all these kinds of projects doing this as a good thing for that species. And then it's not entirely on each project to come up with something. Because these programmatics are mostly discretionary, it's let's work together to define the goals that we want to achieve. What's the scope of this program? What are the actions in the species we will address? Let's look at the species conservation needs. How do your authorities align with them? What could you do to benefit these species under your 7A1 responsibility? And then let's figure out what are the savings in time and costs and efficiency that we want to achieve. What are our goals there? So let's specify that. We can also work together on the effects analyses. We can work together on deconstructing the action, deconstructing the biology of the species relative to action-caused stressors, and we can, just do the whole 9 yards together. We have done this, and I'm sorry, Brian has already left, but we have just finished or about to sign a programmatic consultation with Federal Highways on 2 listed species of bats whose range cover about a third of the country. About a year ago, we completed the informal component of that consultation, and in that year, that 800 projects have already used that informal, process, which defines the class of projects that are not likely to adversely affect if you meet these criteria. And we have a project submittal form, basically, do you meet these criteria, you know, and explain how or why. And then that form is sent to a field office who has 14 days to turn it around. And it's because it's clear, because it's well defined, you know, silence on our part, you know, not returning, not answering that form is concurrence. And we basically get back to you if we found something wrong. You know, oops, you made a mistake. We're about to sign the formal component of that same process that expands the scope beyond the informal actions, a bit larger, and deals with some take of Indiana bats as well. So we went through that whole process as a team, Federal Highway staff and Fish and Wildlife Service staff. We essentially wrote the BA, you know, under their supervision and with their agreement. But, you know, they did a transfer fund agreement with us to develop this program. And I think it's going to be a huge success. As I said, we did this informal thing with Federal Highways. Most programmatics are informal consultations, defining a class of actions for which, you know, the impacts are limited to insignificant magnitude or intensity or discountable probability. And those Corps of Engineers keys, you know, here's if you, yes, you know, project is not located in such and such, you know, project will implement these BMPs, you know. If so, you know, if yes to all the above, not likely to adversely affect. And that's an informal consultation, you know, that we have agreed that, you know, projects meeting these criteria warrant that determination, and we provide advanced concurrence with it. These actions are generally limited in scope, complexity, or timing somehow, and usually have to adopt some standard impact avoidance and minimization measures. And that's how we can expedite those projects. Is if you're doing these things, we're good to go. Some are formal. They get to be more complicated, but limiting the scope of a formal is still necessary. We could not probably do programmatics that would say, you know, cover all road construction in the state for the next 10 years. That's just going to be too big of a bite to try to chew and swallow at one time. There are just too many uncertainties, too many possibilities for really big impacts. So you need to narrow the scope somehow, limit it, define sideboards, define caps, you know, set some ground rules, something that's going to put some bounds on the analysis that we will do in the biological opinion to get to and support a jeopardy, no jeopardy or a no adverse mod determination. It's hard to support that. You know, this action is not likely to appreciably reduce this likelihood of survival of the species in the wild if the scope of the program is unlimited. You know, you put some limits on it, and then it's sort of a worst case analysis thereafter. More so than in project level consultation, programmatics, there's a lot of uncertainties. You don't know. You're defining a program, not a specific project. And where and when and how those projects will happen are not necessarily, can be highly variable. So you need to be clear about what you don't know about these projects and use what you do know. State your assumptions and use the best available data. One trick in these programmatics is to more easily defend conclusions and estimates is to identify known, hotspots. We know this is a really important area for this species. This program doesn't include projects that will affect that area. If there's a project that needs to go there, it will have its own separate consultation. And so that's a good strategy to get to something that we can live with. We have new regulations that just came out this year that are in your printout in tab 19 or 18 of your notebooks that define framework programmatic actions and mixed programmatic actions. These are definitions added to our consultation regs just this year. And these define the circumstances under which you won't get an incidental take statement from the service and which you will when we're with programmatics. Framework programmatic actions are, the take is addressed at project level. When you have the information that's necessary to estimate take that is reasonably certain to occur. Framework actions framework programmatic actions are programs that don't actually authorize, fund, or carry out the projects. And those projects are themselves subject to consultation in the future. A mixed programmatic action is one where parts of it are a framework, there's no funding, authorizing, or carrying out, but parts of it are. And take is reasonably certain to occur with those other parts. And then in that case, we would do a take statement just for those parts and not for the framework parts. This sort of shows you visually what a programmatic BO will address, what's under it. I'm having a hard time reading this line here. The first bullet there, must document a no jeopardy, no adverse mod conclusion. There is no take exempted in a framework programmatic, but we can, do our best to estimate it and track it at the project level. Changes to the status of the species, the baseline, and effects of the program are reviewed and reported usually on an annual basis. So some of this is where efficiencies in monitoring and reporting come in. Each project we specify what information it needs to provide to the program, and then the program does the reporting. Not each project. Once the project has provided its basic data, it's done. And then the program, whoever is administering the program, uses that information to inform the need to reinitiate, to whatever. So the action agency provides a description and analysis of effects. Here's what, okay, the dot, I forgot what I did with this slide. The dashed line separates the programmatic opinion from the project level consultation. And then the project level is where you get your take statement. So at the project level, the action agency provides the description of the project and its analysis of effects according to the guidance in the program. And then the service will verify consistency with the program and then provide an abbreviated BO that says, yep, this is good with the analysis of the programmatic, and therefore, the conclusion of the programmatic BO applies to this project, and here's your incidental take statement, including any necessary terms and conditions. And then the program effect, the project effects, both the adverse and beneficial, and whatever take was exempted for that project are added to the annual program totals. So that's how our framework works. It's a two-step process, 2 tiers. Do the opinion in tier 1, do the take statement in tier 2. Monitoring and review of a programmatic is absolutely essential. My little footnote there. You really have to, you can't just, press the start button and let these things run. You have to drive them. This is not an autopilot operation. You have to ensure that the projects, first of all, are implementing the program procedures as intended. Communication is imperfect. Maybe people didn't get that part about, oh, you're not supposed to, squash that plant when you encounter it. And then you need to, at least annually, reevaluate the status of the species, the baseline, and the validity of the program level effects analysis. And that's an advantage too, because then you're evaluating, you're doing this on behalf of many projects. You're not having to do it for every project. You're doing it for the program. You need to track project level take for the program as a whole, and then ensure that the exempted amount or extent is not exceeded. And then you need to reinitiate as necessary if any of the 4 triggers are tripped. The take-home points on programmatics is to, as I said earlier, work with us, coordinate to define that scope, put as much effort up front as possible to make that project level analyses, take estimation, RPMs, terms and conditions as easy and predictable as possible. We need to, as I said, a programmatic can't be limitless, unbounded. We have to have an upper limit of effects. Acreage, acre feet of water diverted, whatever the case is, established as part of the proposed programmatic action. This program will affect not more than whatever. And then conduct the tier 1 jeopardy and adverse mod analyses based on that limit. Is this species jeopardized if we reach that full maximum or not? And what are the benefits? We've been saying this already, but more efficient project level consultation. Usually we get the tier 2 process is not, depending on the program and depending on the complexity of its project level action, we've done everything from as short as the tier 2 process being a 30-day turnaround, where it's just basically verifying consistency with the program, no take statement necessary, to something longer, like 45 days or 90 days, because we really have to do some work to come up with the take statement and the terms and conditions. But that's negotiable and depends on the complexities. We want to do this to achieve some savings in time and work. If we put too much work at the project level, we've defeated the purpose of doing a program. So you might as well just deal with them all individually. But doing that adds some predictability to your process, and it can expedite it. More importantly, it gets us thinking at a landscape scale instead, and we avoid, piecemealing, dealing with these conservation issues project by project, and instead we look at a larger scope. So because we're doing that, it becomes an efficient way for an agency to address its 7A1 responsibilities. In this program, the Federal Highways BAT thing, we designed a compensation scheme that would apply to all of these projects that want to use this program for a very quick turnaround and predictable project level consultation. And it's just all laid out. The work has been done. You just need to figure out what your impacts were and what is the appropriate compensation for those to offset those impacts, so that this program in effect could have, no net loss to this species and even a net benefit. And that's the bottom line. The benefits of programmatics for all of us is that it's better outcomes for listed species than if we did it project by project. A programmatic BO doesn't really look any different than a project level BO. It's got all the same basic elements, but it has more details on process and procedures, and there are more uncertainties to deal with. You don't have all that project level data on where and when and how things are happening. You have to make some assumptions about those, and that's how you define the scope of the program. We do a take statement in these programmatics only if take is reasonably certain to occur. We can estimate it and provide appropriate RPM at the program level. As I said, I think yesterday or the day before on this BAT thing we've done with Federal Highways, we thought we would need a Tier 2 process to come up with those. When we got there, it's like, oh, we can't really think of anything else we would want to come up with, that's not already addressed in this program. So we sort of zapped the get a take statement at the project level part of it and just provided it at the program level. That met everyone's goals. Better efficiency, and we're not displeased. It wasn't a compromise on our part. It was like, oh yeah, we know that'll be better for you guys, but maybe not so for the species. No, we did not compromise. So it's a win-win. And then last but not least, the monitoring, reporting, feedback loops are really necessary. You don't want to create a monster. And that's out of control, that has no ability to tweak it, to change it, to improve it, to fix some problems with it. Project level consultation, the framework situation necessarily involves getting a take statement at the project level, but it's usually an expedited process. Yeah.
On that last slide, the last sentence you said for the life of the programmatic agreement, so is there an expiration date or is it potential?
Yes and no, it depends. That is one of the things you define. We are going to do this program for how long? In the case of the Federal Highways thing, we did not put a time limit on it. We said we are going to basically use these monitoring, reporting feedback loops to tell us when we think we need to redo it. Basically let the reinitiation triggers govern, when it's over or when we redo it. But like forest plan consultations, the plans themselves have a time limit. I mean, they are effective usually for 10 years or until modified. And sometimes as long as 15 years. If an incidental take statement is issued at the program level, usually you need a quick check-in at the project level, depending on the complexity. It's not like the key with the not likely to adversely affect thing, where really you don't really need additional scrutiny on that. But in this formal thing where take was exempted at a program level and a project wants to use some of that take, we need to have a dialogue to at least increment the amount of take and for tracking purposes. So, but in either case, projects need to provide data according to the guidance in the program. And that's it. That's the programmatics thing, and we're done. Questions? Future?
I do have a question. On the monitoring line, you're evaluating the program project annually, you evaluate the status of the species, and what it's based on. Is that the service in that?
No, it would be done. It would be done together. It's so that we know, do we need to reinitiate? So usually it's a shared responsibility. Because you're not going to necessarily have information that we have on the species, and we're not necessarily going to have information you have on the projects. But that's the sort of thing you work out when you define the program. And certainly if it's one of these discretionary things, it's up to us what we do and don't do.
Do you consider the Army Corps keys that we use, are those considered to be programmatic?
Yeah, they're not really called that, but that's in effect what they are. I think we actually have something called a consultation on the standard local operating procedures for endangered species with the Corps. And those keys come out of that sometimes. But yeah, there is an exchange between us and the Corps on those keys that we have logged as a consultation. And it's an informal programmatic in effect. And if we were doing our jobs right, we would have checked the programmatic box in our little data entry thing for that. But when you look at those keys, it doesn't say programmatic whatever. It just says key for effects determination key for manatees or indigo snakes or whatever. Are we done? Did we have fun? And I want to thank you all for being so great.
I just wanted to take a moment, Natasha, and a couple others mentioned earlier. I said we had 5 DOT liaisons. I think no one was from there. John, but we also have John Suki and Peter Mulholland here. And Peter is, I think, the sport fan on the top. John Suki's been here since so they'll be new, they'll be visiting us, and we'll see their names on board as well. So they're 2 releases.
And thanks to Katasha and the whole DOT team that organized this, and I'm really glad that you asked us. Oh, and remember, if you've got any feedback, our emails are on page 2 of your notebooks. Let us know what you thought, what we could do better, what you thought really sucked, or whatever.